the Japan versus Anas case, that in law, if you allege that the tape is doctored, the onus is on you to produce the authentic version. So where is the authentic version?
Well, the authenticity
and where is the evidence that the tape has
lies
been?
in 26 minutes.
No, come on.
That's what the point.
That's a joke.
That was in your
Evans,
own WhatsApp.
If you call me for an hour, okay, I can have a conversation with you for, say, the first 20 minutes. But if I see from the direction of the conversation that you are up to mischief, I can record from a certain point. You see, so the fact that I don't record the entire conversation, but I record portions of the conversation, doesn't make the tape doctored. So if you see, look, Mr. Jakpa, under oath, whilst testifying in court, told the courts, under oath underline, that the Attorney General has been calling and meeting him at odd hours, impressing on him to falsify his evidence so that he can secure a wrongful conviction of Honorable Atufosen. And he told the court that he has evidence. And he dared the Attorney General that if you dare me, I will open the Pandora's box. Now, if Frank Davis is serious about what he's saying, why didn't the Attorney General object to that evidence? And why didn't he dare Jakpa in the witness box? Because he's the Attorney General. He's a lawyer on record in the case. The Evidence Act allows him to make an objection. He could have even moved an application for the court to expunge that from the records of the court. Dame lost his mojo. He was shivering in his chair. He was silent through the proceedings and couldn't offer any objection. Today it takes these people to hold a press conference to defend an Attorney General who could not defend himself when his accuser was sitting before him in a witness box. Are they serious? What do they take us for?
But the Attorney General it wasn't his turn to cross-examine the accused.
No, it's not about, no. You don't wait for your turn.
You could have raised an objection. But
you could have raised an objection.
On what grounds?
If what they claim is true, that the allegation is vexatious and scandalous. And that same should be exposed. He could have even said that the evidence has no basis. It has no legs to stand on. It's inadmissible. It's not relevant. Or it is scandalous. And that it should be expunged. And the rules of evidence require such an objection to be made timeously. The reason why Dame was shivering in his chair and was silent throughout the proceedings, couldn't raise any objection, even when the court indicated that testimony should be captured on record, is because he knows that what Jakpa was saying is the truth. Because he's a coward, he thinks that he can come into the media to mount a defense he has not been able to mount in court.
You have his day in court where he can cross-examine Jakpa.
Cross-examine who? Cross-examine a person that he is begging to help him make his case and to skew his testimony in a way that supports his case.
On the tape they maintain is doctored. So he gets to put that to him in court.
That the tape is doctored, and I'm telling you,
the tape is
so where is the authentic tape and where is the evidence of the doctrine? Because if they say the reason why they say that the tape is doctored, two reasons. They say, number one, the call lasted for 26 minutes, but the tape is 16 minutes 5 seconds. And I'm telling you that you can call me for a conversation. We can have the conversation for, say, 10 minutes. If midway into the conversation I realize that you are misleading me into something, I can start recording at that point. So the conversation could have lasted for 30 minutes, but the recording will be 20 minutes. This is common sense. It doesn't make the tape doctored. Number two, they say the most ridiculous one. Come on, this is an authentic tape. Everything we have put out today, look, I'm a lawyer, and I know the consequence of putting out false information, publishing false information about somebody. And I know we are dealing with somebody who is the Attorney General. Everything we have put out, the WhatsApp screenshots, the audio recording, which is just one of the many we have, is incontrovertible, it is indisputable, and Godfred Dame cannot deny it. You see, all throughout this conversation, since Jakpa exploded in court and dropped this bombshell, the AG and the MPP have been peddling lies upon lies, and I am very pained that the media still indulges them. Because number one, when this matter broke on the 23rd of May, the AG issued a statement. You read the statement on this show. Paragraph 2 of that statement says, Evans, that the Attorney General, neither the Attorney General or his office or his assigns have ever met any of the accused persons or sought their cooperation in any form. No meeting. Now these same people turn around and come and tell you that, oh, he met him, but he was ambushed and entrapped by a Supreme Court judge. And you take them serious? These liars, you take them serious? They came and contradicted themselves. The dummy that they claim never met Mr. Jakpa. Now they said, oh, he met him, but he ambushed him. Only for us to give you incontrovertible WhatsApp chat evidence that shows that it was in fact the Attorney General who first suggested and chose to meet Jakpa through the Supreme Court judge. The Supreme Court judge knew nothing about it. Jakpa himself never proposed that. But because that is his modus operandi, that is how Dami goes about manipulating the judicial process. That is why his first inclination was to set up that meeting Jakpa requested through